So basically this is okay, so this is going to be our first class of the semester 1 2020-2021. So as we know, the first 2 weeks is going to be online, and the rest hopefully we can meet face to face up to the approval of MKN and KPT. So as for the moment, uh, I know that we have been through online class for like a semester, and then this is our second semester together. And my concern is your understanding on the subject, and also when you are doing your group work, preparing for the work, that will be another problem when you have to discuss with your group mates, and then when you need to submit it to me later, I also do not want you to have unduly a lot of things to do, because I understand your restraint and constraint as students. So I'm trying to minimize your work, but at the same time, I want I mean the learning process to be continuing. So that's why I'm still asking you to do the tutorial questions, so you keep updated, and then know what are the issues, the important principles in civil procedure. So among the important things that I should mention is number one, civil procedure. Even civil procedure 2 is not that difficult. Okay, so basically it's not that difficult in the sense that for civil procedures, first you need to understand the procedures, the legal principles as well, and then that is where your cases case law, is very important. Okay, for you to know not just the name of the cases, but the principles in those cases, and then sometimes they mention about the procedures involved that you have to comply. So that's why in civil procedures, in procedures papers, cases are important as well. Okay, so my lecture is going to be, since it's limited up to 2 hours, so basically I'm going to give you the basic, the gist of the topics, and then tinggal kita berdua. And then there will be a discussion in our tutorial. Okay, so last semester we did not have the face-to-face tutorial. I think this time around we need to have I mean online, the synchronous type of tutorial. So I know what is going on. I don't want to get to like left behind. So we are going to do synchronous session of tutorial. We are going to discuss tutorial questions, so I'm going to look at your papers. Okay, so all 3 hours of our classes, 2 hours of lecture, and 1 hour of tutorial will be in a synchronous mode, because this is your final year. 5th year, first semester, right? Okay, 5th year, 5th semester. So I don't want you since you don't have the advantage of having a face-to-face class, so I want to be in touch with you as much as possible. Bear in mind, you should have this rules. Tak nampak langsung. Okay, rules of court 2012. Make sure you have it handy with you during my class. And then I have this book. I found it useful. A practical guide on CLP civil procedure. This is more like, actually it's like a question and answer thing. Okay, this is quite expensive. It costs 160 ringgit, but they are going to give discount for like 40%. Okay, so this is good because they give you the gist, the basic of the topics, and some question and answers thing. Okay, I found that this is very useful. And Ravi Nico, if you have it, okay, Ravi Nico is good as well because they have this chart. Do you have Ravi Nico with you? Ada buku Ravi Nico tak? Apa kau gelak-gelak mesti kau tak photostat. Jangan cakap photostat.
Ada tak? Syami ada buku tu.
Bagus. Tak kisahlah. Photostat ke beli ori ke, I tak mahu tahu. Up to you. Okay, and of course this. Ada yang cakap this book is banyak kan, content dia kan. But it's dia, so after my lecture, beside reading my PowerPoint, you should read all this book. This is to complement or to supplement your my lecture and tutorial as well. Dia punya principle semua ada dalam ni. Ravi Niko lagi bagus. Sebab apa? Rasa sebab apa? Apa beza buku Ravi Niko dengan Janab ni?
Dia ada bagi sampel.
Yes, dia ada sampel course papers kan? Lepas tu lagi satu dia ada apa tu? Perasan tak?
Okay, hai.
Question and answer.
Okay, question answer. Ada lagi. Yang paling penting buku Ravi Niko ni.
Ada graph.
Yes, ada
Yes.
graph. Yang graph tu I suka. Empat tu bocor sikit I dah kena minum. Banyak nak. Okay. So basically that is the structure of our class. Okay. So but at any time, provided that tapi kau suka je kan message WhatsApp madam malam-malam kan, benda dah tidur kau sibuk lah nak tanya madam macam-macam. Anyway, sebab kita dah jauh kan, madam tangan tak sampai nak piat kau punya telinga. Boleh lah kalau nak tanya apa-apa through the WhatsApp anytime, okay, and FB and also Telegram. Alright. So, civil procedure is not difficult. Yang penting you kena tahu satu principles and procedures. Ini dalam kelas and must for you to understand, and when you do your course papers. Sebab tu you kena pay attention in class. Sebab bila nak buat course papers tu, you must take all the principle, important principle into account, and then you do your drafting. You ingat I membebel-bebel ni tak ada mana. Sebab nanti kita akan guna, kita punya next job is, first is we are going to do a course papers application, and kita try nak buat ni a mini hearing. Kita akan buat, we are going to, have you got your course outline yet? Ada tak? Dia dapat dah?
Kan ada dalam course doktor kan?
Ada kan? Kalau tak silap ada. So just my PowerPoint tu nanti I bagi sebab nanti ada full citation yang I nak kena bagi. And then so masa lecture the basic dia macam tu. Asal dia menyorok dekat belakang tu macam mana tak dia buat tu. And then tapi when it comes to answering soalan dan jawapan, answering question and answer, menyorok belakang I pula. Macam hantu pula dia. Okay. When answering the questions, you need to bear in mind ada two type of questions. One is problem, one is essay. Essay is like straightforward kan? But the problem question, beside putting all the principle, what is important is what? You kena answer the question. Jangan letak semua je kau pergi taruh macam exam kan? Kau taruh je semua apa-apa yang ada kat situ kan? Ingat I tak tahu katnya. So, you need to answer the questions. Bukan letak apa yang you tahu. Bila you put the relevant issues and put the relevant cases, and then your answer will be outstanding lah. Sebab tu ada yang dapat A, ada yang dapat A minus, B plus, B. Okay, how many of you got A? Raise up your hand. Asal angkat tu angkat ke tidak? Macam angkat tak angkat je. I think quite a number of you kan? Got A, and then B also a lot, and C sikit sangat lah. That's good. Zarif bin Mak Nasri dapat A ke? Dia raise out hand ni kenapa Zarif ni?
Dapat A.
Dia dapat A. Alhamdulillah. See? So tak susah kan? Still procedure. Yang penting lecture, do the work in the tutorial. We are going to do a mini hearing. You want to stick to your old firm or you want to have a different firm this time round? Nanti you have your own discussion lah.
We have to discuss first.
And then do the list. Do the list of your firm. I think you will be according to TLB ke apa ke, up to you. I don't want to interfere. Okay. We are going to do a mini hearing. Buka ni. Kita nak apply injunction. Okay. You nak buat Mariva Injunction ke, Untitled Injunction ke, or Interlocutory Injunction ke. It's up to you. You're going to create. You need to create the scenario. Plaintiff. So you have a group, give me your group name, and then you divide yourself into plaintiff and defendant. Kena bagi siap-siap Syami. Bagi plaintiff and defendant, the plaintiff dulu will start. You create your course papers, apa yang you nak injunction from the other party. I give you like, how long 1 week to prepare for the course papers. Cukup tak rasa? And then you dah siap, plaintiff dah siap, and then you serve it on the defendant, and then defender baca and ready, and then we start the mini hearing. I guess first week ni you can prepare. Second week tu the plaintiff will need to do the course papers. At end of the second week they need to submit it to the defendant, and third week tu defendant have to reply, and then we are going to do the mini hearing at the 4th week. 1, 2, 3. 4th week lah. Boleh? We are going to start our mini hearing. Alright, kalau online lah. So basically, what are the principles of our restrictive relief? Preventive measures. Okay, I'm going to share. Share. Aduh, dah lama. Share content Okay. Nampak tak?
Nampak kan?
Okay. So, Civil Procedure 2, LAD 5083, so a different course code. So this is what we are going to cover for preventive relief injunctions. Basically, we are going to do interlocutory injunction, Mariva injunction. Mariva is interesting, and then the jurisdiction, procedure, foreign asset, worldwide injunction, and the dissolution of a Mariva injunction. And then later we are going to cover Interlocutor order, nature, jurisdiction, procedure, and conditions, and then setting aside an Interlocutor order. So this is our coverage for first and second week. So basically, you're going to do either interlocutory injunction for your course papers or Mariva injunction. Okay, this is Mariva injunction, and then Interlocutor. Okay, up to you. Okay, the important act that you must have is Specific Relief Act 1950. You can download it online if you can find it, and these are among the important cases. Okay, the most important is Mariva that describe the principles in granting a Mariva injunction, and then Interlocutor. This is the cases. These are the cases. Okay, classification of injunction. So basically, injunction is a remedy in equity. Have you studied equity and trust before? In year 1, 2 or 3? Ada tak belajar?
Yes, ada doktor.
Year berapa tu? Year berapa tu?
Year 3.
Year 3.
Belajar apa? Apa subjek dia? Equity ke equity and trust?
For semester 1 equity, then for semester 2 trust.
Oh. So you basically learn what are the requirements for Mariva or for Interlocutor. Ada tak apa principles dia? Ada belajar tak? Ke tak ingat dah?
Kita kena recall balik lah, insyaAllah.
Oh, okay. So kalau you tengok, kalau you ada lah nota tu, you ada dia punya principles ada, but in terms of practical, we are going to do in our civil procedure. So these are the important types of injunction: prohibitory injunction, mandatory injunction, perpetual injunction, Okay, interlocutory injunction, this is when the trial is going on, then ex parte and quiet time, injunction. So what is injunction? Injunction is to stop somebody from doing something or compel a person to do something. That's what it means by injunction. Prohibitory injunction is to prohibit you from doing something. Okay. Mandatory injunction. Okay, basically mandatory injunction is governed by Section 53 of the Specific Relief Act 1950. I'm going to put that in notes. A prohibitory injunction is Section 52. And then purported injunction is also known as a final injunction. It takes forever. Okay. And the interlocutory injunction that I mentioned to you just now is a temporary or interim injunction. So it lasts pending a trial. It's applied during the trial, and then when the trial is concluded, and then it will end. After that, you need a perpetual injunction. Okay, this interlocutory injunction is to maintain the status quo until the trial is over. Okay, ex parte is granted only if one party is heard by the court. Ex parte means one party only, and there are reasons why some injunctions are being made ex parte. Do not want to be heard by the other party, and it is to be served to the other party. And then quiet time injunction is basically injunction to injunct the other party from applying an injunction from the court. Okay, so basically these are the classifications of injunction. The most important one that we are going to study in this topic is Mariva Injunction and Interlocutor Injunction. These are special types of injunction because they are created by case law, namely Mariva Injunction, ad interim injunction, Erringford Injunction, and Interlocutor Injunction. Okay, so this is the outline of our course. All right, interlocutory injunction. Let's have a look at Order 29 of the Rules of Court 2012. Order 29 is in your Rules of Court, Order 29. Have a look at your Order 29. Shall we look at it together? Do you have it with you? Ada tak dengan you all? Ke kau punya rules of court dah mana hala dah? Dah bagi adik ipar ke, anak buah ke? Okay. So, Order 29. How many sub rules do they have in Order 29? Ada berapa rules dia?
8 altogether.
Ya ke 8? Okay. Nasib baik betul. So, it means that you have it with you. So, application for interlocutory injunction. Okay. Rule 1, and then detention, preservation, and then power of order sample, perishable property, movable subject, order for early trial, directions. Okay, what are the directions that the court can make, and then income of property pending trial. I give you a scenario. Okay, for instance, you have a dealings, a business, a contract with the other party. Again, the other party is breaching the contract. For instance, you have this, you own this company name, Boba Tea, for instance, and then you enter into disagreement with the other party. They became your subscriber of this franchise thing, but later they create due to whatever trade secret that they got from you on how to do things. Later they invent a new boba tea, okay, which is more popular than your original agreement, your original contract. So, and later they breach the original contract with you. So what you want to do? So you want to have an injunction. restraining the other party from taking whatever trade secrets with you, and then you want to settle your deal with him for breaching the contract agreement. These are among the scenarios lah, okay, where you can apply for injunction. Another type of injunction is, let's say you are married. I always give this type of example if people, like becoming blur. What is injunction is all about? So basically, let's say you are married to a foreigner and then you got divorced. And then he goes back to his country, bringing all your children together with him. You do not want that to happen. So you ask this injunction from the court, okay, preventing him from bringing all your children back to his home country. That is another type of injunction. Okay, so basically, interlocutory injunction is a temporary or interim injunction. It usually lasts pending trial, and then after trial, you need a perpetual injunction that I mentioned to you just now, and then these are among the important cases: Jacob Renner, Sam Peng Tong, and Chia Cheng Lan, Heng Li Yi, and others, 2001. So I'm going to give you a gist of these cases. Okay, later you can have a look at on your own. So basically, for interlocutory injunction, okay, the process. Okay. Not this one. No. How am I? Okay. Wait. All right. So basically, how do you apply interlocutory or any type of injunction? Like I mentioned to you just now, is through Order 29. Okay. All right. So basically, you need to do it with notice of application. Do it by notice of application. Remember, we have some modes of comments and action, which are read of summons, lagi. Okay, this is a type of commencing, but it's called a notice of application. Dia ada form dia. Okay, notice of application. Usually when you do notice of application, you do it with affidavit. What is an affidavit? It is a sworn statement. Have we done it before? Did we do summary judgment last semester? Summary judgment course papers, Syami?
Summary judgment.
Course paper, did we do it?
Yes.
Yes.
Kan? So
yes,
you do your notice of application together with affidavit, kan? To apply for summary judgment. So for injunction, you do it by way of notice of application, and then the notice will fix the hearing date, and then you have to serve it on the defendant, notify him within 14 days, and then the form it is in form 53. And then on the hearing dates, both parties will attend court, and then they will need to argue whether the court should grant an injunction or not. Okay, so this is not an application per se, but we are looking at it from the bigger picture. You have served your writ of summons first, or whatever OS that you have against the defendant. That thing is still going on. Okay, they have a different date, but you have a different application for interlocutory whatever injunction. This is a different application, so a different hearing date. Okay, the case is still going on for this interlocutory injunction. The trial is not over yet. You understand what I'm saying? Dia bergerak sekali lah. Okay. So you dah ada you punya writ of summons or OS, and then If it's an urgent matter, Order 21, Rule 1, Sub Rule 3 must be complied. Okay. He need not commence in his action in the court. He can apply for an ex parte interlocutory injunction. Okay, and then the affidavit, he must comply with Order 29, Rule 1, Sub Rule 2A. Okay, I think this is going to be covered in a different, let me, I think I have it in one of the slides. Oh, no. I thought I have it in the slide, but it's not here. Okay, never mind. You just focus on the slide only. Okay, so basically, the court will fix a hearing date, and then if it is an ex parte hearing, only the plaintiff will attend. So ex parte injunction means only one party appears before the court, meaning the other party is not there. Okay, so usually it's inside the chambers, whereby the judge, only the plaintiff solicitor will be presenting before the judge without the presence of the defendant solicitor. Okay, if the court grants an ex parte injunction, the ex parte will only last for 21 days. Okay, you need to remember this for interlocutory, 21 days only. And then after 21 days, the ex parte injunction will automatically lapse. Okay, and then the court will fix a hearing date for an inter parte interlocutory injunction hearing, and then it is after 14 days. Okay, so basically that's the procedure for interlocutory application. All right. So the inter parte later is hearing to hear both sides. Okay, the purpose of the inter parte hearing later is the ex parte application in the first place should be discharged or dismissed, whether to grant an interlocutory injunction or that will last up to the conclusion of the trial. All right, so basically that's how the interlocutory injunction will in practice. So in real practice that I mentioned just now, you file a statement of claim together with a writ, and then later with an ex parte notice of application with affidavit. Okay, if the plaintiff wins at the end of the trial, he can apply for a perpetual injunction. He must plead for the injunction in the statement of claim. He will plead for a final injunction. So basically, that's how you do it. You must plead it in the statement of claim. Okay, remember last time we learned about the pleadings. You are bound by the rules of pleading. It must be within the boundaries of pleading. If you don't plead for it, it won't be. You cannot argue about it. These important cases, you need to recall. You need to know for this interlocutory Jacob Renner. So in this case, basically, the judge Lau Hotbing allowed the ad interim injunction pending full determination of the final interlocutory injunction. So basically in this case, the first plaintiff was a disabled child who was prevented from attending a secondary school by the board of directors of the defendant. The court ruled that the injunction should be given to the plaintiff. So the first plaintiff would have access to his basic constitutional right to education. That is in the case of Jacob Renner. Okay, in the case of Sam Peng Tong, in this case, Sheikh Ahmad Helmi judge held that the ex parte injunction to run the next day on 1st June for the purpose of the calculation of 21 days. Therefore, when the ex parte injunction lapsed on the 21st of June, Okay, the fixing date of the return allowed the judge to consider full agreement from both parties to determine whether an inter-party injunction will be granted until the matter is disposed at the trial. So first, the judge will hear the ex parte application first. Alright, and then they will go. He will go to the inter-party application. And the case of Chia Cheng Lan and Hia Yi Li, Lamin Muhammad Yunus PCA held in conjunction with Order 29, Rules 1 Sub 2B and 2A. 2AB, the lifespan of the ex parte injunction is last for 21 days. It cannot be extended beyond that. Okay, Order 2092 Rule 4 cannot be invoked to extend the ex parte injunction. So you cannot extend the ex parte injunction. And in order to apply for this interlocutory injunction, you must have this undertaking as to damages. So basically, what does it mean? It means basically promise made by the plaintiff to the defendant. If the defendant suffers any damages as a result of the interlocutory injunction, at the end of the trial, he wins the case, the plaintiff promises the defendant that he will pay the defendant's damages for any loss suffered by the defendant. The case is Elias Muin, another, and Datuk Zainal Abidin, Johari, 1997. Okay. Any questions for interlocutory injunction? Okay, so these are the important principles in granting injunction that you must know. Okay, the landmark case, you must know. Have a look at this case. Not just have a look. Do a, what is it called, Shami? When you do a review of a case, what?
Case review.
Yes. You do a case review on your own on this case. American Dynamite and Etiquette. 1975 is a House of Lords case. I'm not going to do it with you. I'm going to do with you another case. But it's important for you to read the facts of the case, and then I guess you will get an overall view, picture of what injunction is all about. So these are important. When you draft your course papers, make sure you have you have all these elements. I'm the judge. I'm going to look at the plaintiff's side and then the defendant's side. I'm going to look at your arguments. What are your arguments? Arguments that you must have. Number one, are there any serious questions to be tried? You must state that. Convince me. What are your points? What are your serious questions to be tried? Is it about copyright? Is it about licensing? Or is it about guardianship of your children? Or you're afraid that your children might be abused or things like that? If it's serious, yes, the court will give you injunction. If it's not serious, the court will dismiss your injunction application. So later when you practice, when your client asks you to do this injunction, it costs a lot of money, you know, to do this injunction. To say it range from the cost, the fees is like 10,000 ringgit, starting from 10,000 ringgit. So it's a lot of money. So pay attention. Okay. Number two is, are damages adequate remedy for the plaintiff? Can you compensate the plaintiff by money? If it's yes, there will be no injunction. If you can pay the plaintiff with money, if damages is a good remedy for the plaintiff, the court won't give you injunction. If it's no good, if you cannot compensate the plaintiff for all his losses suffered, Okay, so the court will ask you next question. If the defendant wins the case, can the defendant then be compensated by damages? Okay, I give you a scenario. Okay, the plaintiff in this case say she lost her children forever if the injunction is not given to her. So the court say that, okay, if you compensate money to the plaintiff, well, damages will be good enough for her, apart from her children. I don't think so. Okay, so in this case, it is likely that injunction will be granted by the court. On the next scenario, if the defendant wins the case, can the defendant be compensated by damages? So if the answer is yes, injunction will be granted. Defendants can be compensated by damages and then injunction will be granted. If he cannot be compensated by damages, so the court will ask next questions on the issues of balance of convenience. Does the defendant suffer hardship? If the defendant suffer hardship, injunction will not be given. Okay, the case is Kid, Francis, Noel Jones, and Muhammad Noor and others, 1995. Again, this is important case that you need to know. Okay, read this case. Okay, do your own reading of the full of this case. Alright, the case of Kid Gerald Francis. Any questions so far? So you have an idea on how you do your injunction later. So in your course papers, make sure for the plaintiff, make sure you prove number 1, you have serious questions to be tried. If you are clueless at all about how to create a scenario, how to do your points, you can look at the case laws that I gave you, and then from the case law, from the facts of the case, you can sort of imagine the scenario and then you can put up your points against the defendant. Okay, like what you did last semester, I see a lot of creative application. Do like that. Okay, this semester. And number 2, the plaintiff, you must argue that damages is not an adequate remedy for the plaintiff. You argue the plaintiff, you please listen, or else later you will be in the how a plaintiff should argue. What are the points? This is the second point. You need to argue to the court that damages is not adequate for us. Okay? And then the third question, the third thing that I want to see in your course paper is that if the defendant wins the case, can the defendant be compensated by injunction? You are saying yes, yes, we can compensate the loss of the defendant, or if the defendant win later, they can be compensated by damages. Okay, plaintiff must show that, and then you will have your injunction will be granted. And then you are going to show that the defendant does not suffer that much hardship. Okay, you have to show that in your course papers, because the court is balancing of the taking the approach of balancing of convenience between the plaintiff and defendant. Okay, so it now raise the question. That's the plaintiff side. So what will be the position of the defendant then? So the defendant need to argue then the reverse of what the plaintiff have argued, right? Number 1, you need to argue if the plaintiff is saying that there are serious questions to be tried, you are saying it's not a serious question. So you are saying it's not a serious question, there is no injunction. Okay? Don't just say serious question. You must put your point. You're saying, like, let's say you are saying, you have about the battle of custody of children. You're saying, no, you are saying, I still allow my ex-wife to come and visit. My wife have the custody of my children. She has their passport. I cannot go out from the country, you know. I'm not that mean to bring the children out of the country. There is no serious issues to be tried. Don't just say serious questions to be tried, but you need to state your facts of the case. Number 2, the defendant, you must say the damages is adequate remedy for the plaintiff. You need to rebut the plaintiff argument. Okay, so there will be no injunction granted to the plaintiff. And then next, you should argue that if you win the case, you cannot be compensated by damages. Okay, so meaning the injunction will put you in hardship. Okay, so that is the third point that the defendant must argue. And then the fourth point is you will suffer hardship. And then that's how you are going to rebut the injunction application by the plaintiff. Don't just put up your points, but you need, if you want to have the ideas on how to rebut the case, look at the case law. Okay, they have some good points there. Alright, so are you ready to do your injunction application? Yes? No? Do you have the idea on how to go about doing it? Boleh?
Doktor,
Ha.
tadi kan Doktor ada mention kalau kita orang boleh pilih antara Interlocutory Injunction, Mariva ataupun Untitled tu kan.
Ha.
Tapi kalau macam Mariva tu biasa kan dia ex parte application. Kiranya court akan decide tanpa panggil semua parti. So kalau dalam tu kita orang kan kena divide plaintiff and defendant. So in terms of cost paper tu nak jawab dengan balas tu tak payah ke macam mana? Boleh pilih ke macam mana?
So maksudnya kalau misalnya Mariva Injunction tu ex parte kan, lepas 14 hari tu the court will panggil for interparty. I will call both parties lah. First tu I nak dengar je dulu apa argument dia, and then I will have to call for the next part, the other party punya defense pula.
Oh, I see. Okay.
Yang macam I explain asal tadi pasal ex parte. Kalau ikut dia pasal 14 days lah kan, tapi kita tak adalah masa nak 14 days kan.
Oh, kiranya contoh, kiranya plaintiff boleh hantar ex parte application tapi kita deem as kita anggap macam dia dah lapse within 21 days and then doktor call for ad interim doktor untuk call defendant.
Ad interim. Ad interim tu interlocutory. Kalau Mariva tu dia bukannya interlocutory lagi tau. Mariva tu is apa orang kata? Oh ya. Mariva dia boleh interlocutory. Okay, ya. So maksudnya kira questions of yang dia sudah lapse lah. So sebab kita nak for a matter of right, I nak dengar both side tu kira interparty je lah. Kita cut it short lah.
Okay. Boleh.
Alright.
Thank you, doktor.
So you got the idea or not what to put in your course papers? Apa yang you kena points out by the plaintiff and the defendant?
Basically, hari tu senior alumni ada share dengan kita orang semua contoh-contoh contoh-contoh course paper. So rasanya semua orang boleh refer kot sampel tu. So nanti nampaklah requirement dia macam tu kot.
Okay. Ada tak yang buat Mariva Injunction?
Sekejap saya check.
Okay, so basically these are the principles. Dan nanti Alia nanti bila dah habis check, you just interject my session.
Alright.
Okay. Next is the Mariva Injunction. Habis suara rasa. Okay, Mariva Injunction is a limited type of injunction. So ni benda yang penting lah for injunction. The purpose is to restrain the defendant from removing, disposing or concealing his assets from the jurisdiction. So it freezes the defendant assets and the operation of the bank account. Okay, this Mariva injunction originates from the case of Mariva, Compania Niviera SA and International Bulk Carriers SA. Is in a 1980 case reported in All England Law Report. Okay, and it's called as the Mariva. Okay, have a copy of this case and do your own case review on this case so you will know what are the facts of the case. But I have taken the trouble to look at what Lord Danny has to say in Mariva Injunction. I think this is ever going to be maybe the only time we look at this Lord Danny judgment in this case. So basically, in this case, Lord Danny, okay, he raises some important points. Okay, it follows a recent case of Nippon, Yusen, Kaisha, Ankara, Georges. So basically, in this case, the plaintiff are ship owners. They own the vessel. The vessel name is Mariva. So Mariva is the name of the vessel. Okay, they let it to the defendant, the charterers on the trip out to the Far East and back. So Alian, can you find it or not yet? Okay, so basically the vessel was to put at the disposal at Rotterdam. Rotterdam is in Holland. Okay, and it's payable half a month advance. Okay, these are the terms of the payment, and then the vessel was duly delivered to the charterers, and then the charterers sub-chartered it. Okay, they let it on a voyage charter to the President of India. Okay, and then these are among their agreements, and then it was loaded at Bordeaux in France, I think. Okay, with a cargo of fertilizer and consigned to India. Okay, what happened was the Indian High Commission paid 90% of the freight, paid in bank in total, paid it to a bank in London. Okay, and then the amount was 124,000, and then the charterers paid the ship owners. All right. They paid those installment transferred to the ship owners, but later, the charterers failed to pay for it. Okay, they could easily have done it, but they did not make a credit transfer in favor of the ship owners. At that time, they used telex. Telex is sort of kind of fax kind of thing, but it's older version than that. So it was quite plain that the charterers were unable to pay. They were not able to fulfill any part of their obligation. In the end, they have no alternative but to stop trading. Okay, their efforts to obtain further financial support had been fruitless. Okay. And then the ship owners already treated the charterers' conduct as a repudiation of the charter. They issued a writ, the ship owners issued a writ. They claim unpaid hire and damages for their repudiation. The total was very large. Okay, they served the agents. They apply also service out of jurisdiction. And also they believe that there is a grave danger that these monies in the London bank will disappear. Remember, I told you just now, the High Commission of India has already banking the money in London. Okay, so these ship owners, they apply for an injunction to restrain the disposal of those money which are now in the bank. They rely on the case of Nippon using Kaisa and Kara Georges. Lord Denning mentioned that Donaldson J. felt some doubt about that decision because we were not referred to Lister and Company. There are observations in that case that the fact that the court has no jurisdiction to protect a creditor before he gets the judgment. He was referring to the case of Cortel J. Okay, Cortel J held that I know of no case where it was highly probable that if the case were brought to a hearing, the plaintiff could establish that a debt due to him from the defendant has been ordered to give security until has been established by the judgment or decree. So meaning that until the case is being disposed of and then there's no security for the plaintiff, that was what Donaldson J believed based on Cotton LJ case. Okay. So he's also referring to the Lindy LJ, where we should be doing which I consider to be great mischief if we were to stretch a sound principle. If the defendant asks us to stretch it, so the previous High Court judge referred to Lindy as well, and then also Donaldson J felt that he was bound by Lister, that the court had no power to grant an injunction. But in difference to recent case, he did grant an injunction on the understanding that by that time this court would be able to reconsider the position. Now the counsel for the charters have been helpful. It has drawn our attention not to Lister but also this Supreme Court of Judicature Consolidation Act 1925, where it says a mandamus or an injunction may be granted or a receiver appointed by an interlocutory order of the court in cases in which it shall appear to the court to be just and convenient. Okay, so basically the counsels are referring to this, arguing based on this, and then the embedo just this is what the judges have been referring, okay, from what Lord Danning's statement. Just MR, Master of the Road, gave a very wide interpretation. He said that I have unlimited power to grant an injunction in any case where it will be just or right to do so. Okay, so meaning that there's only one qualification that need to be made, is that the court will not grant an injunction to protect a person who has no legal or equitable right. That appears from the case of North London Railway, but subject to that qualification, the statute gives a wide general power to the court. It's summarized in Housebury Laws of England. Okay. And this Housebury Laws of England, whenever a right which can be asserted either by law or equity does exist, okay, the court is enabled by virtue of this position to grant an injunction to protect that right. So these are among the arguments for and against granting of injunction. The case that have been referred to in their arguments during the case of Mariva Injunction, the Mariva case. And then by that virtue, Lord Danning granted an injunction application. Okay, so that is the origins of the Mariva Injunction case. Okay, so we look at Lord Danning judgment just now. And then this, based on the principle from the Mariva case, this Mariva injunction was applied in the Malaysian case of SNF International Transcon Engineering Sdn Bhd, Norihan binti Taleh and Muhammad Nasir bin Hassan 2018 and Zainal Abidin bin Haji Abdul Rahman and Sadri Hotel Sdn Bhd 1985. Okay, that is how our Malaysian court apply Mariva injunction in Malaysia. Alright. So, next. You can read these cases on your own because what we must know is I'm going to cover it later. Procedure for this Mariva injunction. In order for you to apply for Mariva injunction, these are the procedures for you that you need to comply with. It is to be ex parte, or the defender might quickly dispose and conceal his asset. Okay. To do it by Order 29. Rule 1, Sub 2A. Okay, Order 29 is in your rules of court. Sub 2A. Okay, detention or preservation of course of matter. So basically this is stated in your Order Rules of Court 2019. Okay, you do it with notice of application together with affidavit. Alright, so basically in the case of Motorsport International and Delcom, Malaysian Sdn Bhd, the requirements stated in Order 29, okay, especially must be strictly complied. You must strictly comply with the terms in Order 29. And then by the case of Pacific Center Sdn Bhd and UEM Berhad, the plaintiff must show risk of disposal of his assets. Okay, so when he shows risk of disposal of the defendant asset, okay, the onus is on the plaintiff to show a prima facie case against the defendant. So that is how he can be successful in his Mariva injunction application. And then in the case of third channel shipping, this is another case that you must know. Okay, 1979, there are 4 requirements. Number 1, you must have a full and frank disclosure. Number 2 is there must be a real risk of the defendant that they are going either to conceal their assets or quickly dispose of their assets. Number 3 is there must be reasonable ground for the defendant to do that, to dispose his asset or to conceal his asset. The fact that the defendant is a foreigner is not a good ground yet. You must use reasonable ground. And the number 4 is the terms must not be ambiguous. That is how you apply for Mariva injunction. Alright. And then these are the cases that you must know. Peasants Limited and Chin Teck Kwan. The requirements are the same like in the case of Chandris. Okay, must have good arguable case against the defendant. You must show that you have clear evidence that the defendant has assets with the courts, okay, within the jurisdiction. And then number 3, there must be clear evidence that defendants will dispose of his assets. Okay, these further cases, Creative Furnishing and Wong Koi and Region Decorators Sdn Bhd another and Michael Chi 1994 further supported this requirements in the Mariva injunction application. Alright. The foreign asset, what will be the position of if the assets are outside Malaysia? You can apply for this worldwide Mariva injunction. as in the case of Metro Wangsa Asset Management Sdn Bhd and Ahmad bin Haji Hassan and others. And then in the case of Rosa and Envy and Oriental, the court held that only in exceptional cases the extraterritorial Mariva Injunction will be granted. Alright. Okay. So basically, those are the important requirements of the Mariva Injunction. I relate to you just now of the basis of the Mariva Injunction case. And I also mentioned to you just now on the procedure, on the requirements for you to show for Mariva Injunction. So far, any question? I'm running out of breath. So how to stop sharing? Dah masuk ni tak? Ke I still share the slide?
Still the slide appear.
Macam mana I nak stop sharing the slide tu? I tekan mana?
Dekat bahagian share button tu, Doktor klik balik.
Mana I nampak share button? Syami?
Dekat bahagian atas, sebelah kita punya mikrofon tu, dia ada satu button share. That one, klik balik.
Okey dah. So dah nampak muka.
Okey dah.
Habis dah contents. Habis idea I. Mengapu. Okay, so boleh. Principles of Mariva Injunction or principles of injunction in general. Alia, ada nampak ke Mariva Injunction application? Ke tak ada? Sebab dia ex parte juga.
Tak ada. Yang sini share tu interim prohibitory injunction.
So dia orang buat interim prohibitory Sebab dia tak ada dia ada parti
Tapi dekat dalam buku Rabiniko tu ada contoh-contoh apa? Mariva punya.
Dia ada contoh interparty ke? Ke tak ada? Ke application aja?
Ex parte juga.
Ex parte dia memang ex parte.
Mariva.
Dia memang ex parte pun. Sebab dia ni. Tapi later dia need to apply for ni lah. Perpetual. Bukan kuliah. Program. Okay. So, do you have a clear idea how to do your course papers, what to put in your course papers, all those requirements? Rasa-rasa boleh tak nak buat? Saya nak stop recording pula. Tekan sini lah. Oh, wow. Macam mana? Okay. So,